podcast today. My name is Cindy Speaker. I have with me as my guest one of my favorite guests, Nathan Gouen of Gardberg and Kemmerly. How you doing, Nathan?
I'm doing very, very well. Thank you very much. That's very flattering.
Oh, always good to see you.
You too as well.
Always, I always enjoy it. Well, when we talk with Nathan, we have a library of videos where Nathan has talked with us about various aspects of veterans disability law. And I hope that you'll look there. We'll put links to the library on this page so that you can find those other ones, because so much of it builds from one another. And today, the topic we're going to talk about is increased ratings. But Nathan, before we start, let's just make sure foundationally that we understand what a rating is and how that comes into play in a veteran's disability claim before we talk about increasing it.
Yeah, absolutely. So every veteran who has a service-connected disability will have either a specific rating for that one disability, which would also be its total rating, or if they have multiple, they would have individual ratings for each condition and then a total rating. So, for example, in that basically correlates with how much you get paid. So if you have 30% for PTSD and that's your only service-connected issue, you'd have a 30% total rating, and then you would get paid at whatever the current rate would be for a 30%.
Okay.
A 30%, compensation rating.
Okay, so at what point would it be appropriate to talk about a ratings increase?
So obviously, to talk about a ratings increase, you would want a rating first. And so usually, that's the first step, which is pretty easy. And then other than that, if you're a veteran, if you feel like you're entitled to it, whether you have an attorney or not, if you feel as if your condition's gotten worse, whether it be based on your medical records or just everyday activities of daily living, then that would be the time to think about it. And if you have an attorney, to approach them to discuss it for an evaluation of whether or not it would be appropriate.
And what kind of evidence do you need to present in order to justify a potential ratings increase?
So there'd be two different types of evidence that you could submit, actually really three. You can always submit lay evidence, which I think we've talked about in an earlier video.
But cover briefly for us.
Yeah, so lay evidence would be anything from, and those are really helpful for like PTSD and things like that, or musculoskeletal injuries. That a lay statement or lay evidence would be a statement from either the veteran or family member, friend, whoever it might be, that can personally attest to whatever disability it is, its progression in severity, its current severity, veteran symptoms, things like that. So anybody who knows the veteran personally, including the veteran themselves, can write a statement and submit it to the VA for consideration as evidence.
Okay. So, and is there? You said there were a couple times. Is there other types of evidence?
Right. So the lay evidence would probably be the least valuable in terms of an increase, but I just wanted to touch base on it just so people know. The second would be obviously medical evidence, and that would be things from your doctor, specifically saying if you have like a knee problem, knee progressively worse, more arthritis than we've seen in the last MRI, things like that, that are objective medical findings. So those are always good too. The third would be, I would say, subjective medical evidence, and it could also be kind of a combination of lay evidence from the veteran. So that would be things like impairments in your activities of daily living. So if you have a back disability and you used to be able to walk 30 minutes before you had to sit down, and now it's down to 15 and you have to rest longer to get back up. Things like that have changed or progressively worsened can also be considered for an increase, and those are also important.
Are there specific formats or forms? How is this all presented on your behalf?
So you can do it a number of different ways. Sometimes if we just have medical records that have the evidence, we'll draft up an argument, basically submitting those records and highlighting what we want the VA to know.
Okay.
Probably an easier, more effective way to do it, if you have a good relationship with your doctor, someone who's willing to do this, is for almost every condition, there's what they call a disability benefits questionnaire. Or a DBQ. You can find those online. You can Google them or go on the VA website. You can pretty much find them pretty easily on the internet. And we have them at our office too, saved on our server. And those are VA forms that are based on the diagnostic criteria. And so a doctor can go through that and check the boxes, fill out the any kind of subjective part where they need to pencil it in, but most of it is going to be check boxes. And those check boxes and different things like that correlate specifically to a percentage rating. So those are the most efficient ways, I guess, to argue it, because if you just send in, you can say, hey, I have a DBQ from Dr. X and it's your form and we've got bam, 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 here's the evidence in it. Then you can pretty easily say they're entitled to an increase to whatever percentage it might be. So DBQs are probably the most helpful if you want to be the most efficient.
And when an attorney such as yourself is involved, I would imagine you help to gather this evidence and put this all together.
Yeah, absolutely. That's one of the benefits, I guess, at least of our firm is if you have VA doctors, a lot of times if you're only going to the VA, which a lot of our veterans do, they're not willing to fill out this form some of the time. Some private doctors aren't. They'll get a little, they may not be comfortable with it. And so the good thing is that we've got some different avenues, some different connections across the country that do medical opinions. And so,
excellent.
If you have a doctor who's unwilling to do a DBQ or some kind of opinion for an increase, that might be something we might be able to send out to one of the people we know, send out your file for a records review, and then they can write up an opinion on that. So there are a lot of ways to do it, and that's one of the benefits, I guess, of our firm is that if your normal doctors in Mobile or wherever they may be throughout the country aren't cooperative, we certainly know some that are and are very fluent in the VA language and terms and know what they like to see.
Very helpful. Very helpful. Let me read this next one because I want to get it right. Can a veteran or their attorney submit a Nexus statement, and I know we talked about that, for ratings increases as they can for claims for service connection? And mention what a Nexus statement is briefly, although just to let people know, we do have a video specifically on that.
Absolutely. So a Nexus statement, just in short terms, because you can go see the video, is a doctor or a medical professional of some kind saying that this currently diagnosed disability or condition is related to this veteran's period of service or service-connected condition if it's like a secondary issue. So it's some doctors saying that because of A, then C, basically, and in between, there's a link, B being the link of between the injury in service and the current diagnosis. And so a lot of people, because of that, kind of getting into the question is, they think that Nexus statements are really only for service connection, which is technically true, I guess, in the truest sense of the term Nexus. But kind of like we talked about before, that you can always submit DBQs or independent medical opinions that look similar to Nexus statements in content. But instead of rendering opinions saying it's as likely as not related to service, they can say after review of the files, the medical evidence, the diagnostic criteria, whatever it may be, I believe that this veteran is entitled to X percentage for this condition. And so you can use them largely in the same way as you can for service connection. But sometimes that you kind of forget about it once you get service connection, but you can still use them. They're very useful.
Okay. Now, if a veteran does apply for increased ratings, how long does that process take typically?
So depending on what part of the process you're at, it can take varying amounts of time. So if you get an initial rating decision, your next step would be to file a notice of disagreement. And right now, notices of disagreement are taking between 2 and 2.5 years to get processed to get a decision back to us. And that's difficult, been a little difficult. Obviously, people are frustrated by that, and we're doing everything we can on our end to make that as good of a situation as we can from our end, although we're somewhat limited. So for NODs, it's taken 2.5 years, and if you're at the point where you get a statement of the case and you're appealing it to the Board of Veterans Appeals, at that point it can take 3 to 4 years to get a hearing date set. So it's really a timely process. That's why we try to, get all the best evidence we can in as early and as often as we possibly can to try to cut down on that. And there is a new system coming out, new VA appeal system next February. So we should do a show on that at some point, but we won't get in there. Hopefully that'll help. But right now, depending on where you're at, it's taking anywhere between 2 to 4 years, depending on what point.
Now, are the benefits all retroactive?
So it's both. So what they'll do is you won't be penalized for the wait, obviously, other than the fact that you just won't have the money at that point in time. But if they do grant an increase and the effective date goes back to the application or whenever it may be, back in time, obviously, from the date of the decision, they will pay you all the accrued benefits that you'd be entitled to for that. So that'd just be the difference between whatever. If you had a rating, it'd be a difference between your past rating and the new rating. So if you're getting 30%, they raised you to 50 total, they would pay you the difference. But if you had no benefits, if you're going from 0 to whatever it might be, they'd pay you obviously back that way. And then they'd also pay you forward looking as well. So you get the back benefits that you were waiting for during the pendency of the appeal, and then you get the regular monthly compensation going forward from there.
Okay. Very good. Once again, you're a master of these topics. It's very interesting.
I appreciate it.
And honestly, I admire your knowledge of all these, because you just kind of rattle it off, and it just seems like second nature to you.
I appreciate it. That definitely makes me feel good. I hope it's becoming second nature. Sometimes it can still be pretty challenging, but it's always fun.
That's good. Well, Nathan, if someone has questions, how can they reach your office?
They can give us a call at 251-343-1111, or they can find some more ways to reach us at our website, www.gardberglaw.com. That's GARDBERG law.com. You can find our number there, and you can also find a contact us section where you can send us an email if you'd rather do that.
Very good. Well, thank you for being with us today.
Well, thank you for having me. I'm glad to get the information out, and hopefully it's helpful.
Yes, definitely. Okay, thanks everyone for joining us today. If you have questions, comments, feel free to leave them on this page. We'll get your questions answered, and we'll see you all again soon. Bye.